The last video got cut off for some reason, so we're gonna pick up where we left off. But as we were talking about with the Supreme Court, just a quick review was that there's 9 members on the Supreme Court. That number is not mandated by the Constitution, but it's been precedent since the mid to late 1800s. Supreme Court justices are nominated by a president and voted yes or no by the Senate. Just a majority vote, doesn't have to be that 2/3. They're independent, autonomous, isolated from public opinion. They shouldn't care about what people think if what they're doing is constitutionally consistent. Um, the problem is there are times when the Supreme Court could be wrong and they're still isolated from public opinion, so there's really nothing at that point that citizens can do. And that leads to one of the questions that I wasn't quite getting to yet, but I want to pose is um, Biden has just done something that I don't think will go forward politically, but it's a major statement that he's making, which is that he's trying to propose term limits for Supreme Court justices. I would give that about a 1% chance of success, maybe less, for a lot of reasons politically. But the idea is that there is, and I think there are a fair number of Republicans as well and independents. I don't think this is necessarily partisan. I think there are people who believe that the Supreme Court should not be there just forever. It's kind of like a teacher who gets tenure at a university and then, let's just say, is super mean and horrible to the students, but because they're locked in their contract, there's no way to remove them. That's the concern with Supreme Court justices. On the other hand, the Supreme Court would argue that we can't be limited to terms because we need to be able to focus on the long run picture of what's constitutionally correct. And that leads us just back to a quick review. As we were saying, the cases that come to the Supreme Court have to be of constitutional nature. If you want to write down a two-word term that comes from a court case of Marbury versus Madison, I'm less concerned you know that case than you know what it established, which is something we call judicial review. Judicial review are the 2 words you should know, and that's essentially what we've already been saying. That ultimately, if there is a question of constitutionality, the Supreme Court can be the final decider on that. They can be the final arbiter. They can make the final decision, and then all 50 states would have to comply. Now, remember, we did talk about in federalism that a host of states flagrantly disobey the federal government and have legalized weed. California and 30 some other states. Uh, but that, remember, is not because the Supreme Court has allowed them to do it. It's that the Supreme Court ruled Reich v. Gonzalez. I remember telling you about, or Reich versus Ashcroft. It was because an attorney general switched places during then, so there's 2 names for the same case. The Supreme Court ruled that almost 2 decades ago that marijuana was not legal in the states, even though they had legalized it. And in terms of the eyes of the federal law, it was still illegal. Um, I guess the good news for states that feel like that they should be allowed to legalize weed, like California and a lot of others, but Nevada, etc., Colorado, Oregon, Washington, they feel that it's none of the federal government's business to come in and to raid their dispensaries and throw people in jail. And as we discussed, most presidents, I don't think it'll ever happen again where a president will enforce federal marijuana law harshly in a state, simply for no other reason because it's going to be politically costly, not just costly in terms of the actual undertaking. And then we said that a case makes its way to the Supreme Court by appeals, so that the idea is that almost essentially never, almost never does a case just go straight to the Supreme Court's desk. Now, what they can do, and sometimes do, is to fast track a case. So, I'll give you an example. You may have heard of before, but when Oberfeld versus Hodges was passed in 2015, was a Supreme Court decision, voted on by the swing vote was a Republican nominated Justice John Roberts. Um, the decision in that case was fascinating because what it did was it kind of divided conservatives into a group that thought this is a good thing and a group that thought this is a bad thing. The conservative argument for gay marriage is that it's none of the government's business who you enter into a contract with. Um, and so as Oberfeld versus Hodges is passed and the Supreme Court um, sides with the idea that states can't prohibit people from getting married based on what anything. Two people can get married, period. So, was shortly after that, a lady named Kim Jones was in Kentucky working at the city clerk's office. Her job is to hand out marriage licenses, and she didn't want to. She said she didn't agree with it. She said that she felt it was against her religion. And so the Supreme Court did something that is very rare, but as I was saying, it can happen, is to fast track this little separate issue, which was the one person uh, issue that was going to apply to everyone, which was they basically said for all the Kim Joneses out there who work at a government office and don't want to or don't feel it's right to give a marriage license to a gay couple, then you need to go work somewhere else because you have to. You're breaking the law. So the Supreme Court can do that fast track type of case. You've seen it happen with Trump. I think any objective observer would say that Trump's had a massive amount of good fortune, favor from the Supreme Court. And Democrats would say that that's why Biden would say that's why there need to be term limits because an unlimited loyalty to a party or person, and to a person that can never, the Supreme Court justices never be fired is a dangerous thing. But if you remember what I'm talking about, the specific ruling by the Supreme Court, two things. One, that there's the 14th Amendment, among other things, um, talks. It's something important in American history, and we'll talk about this more in a couple weeks, or maybe a couple days actually. But I'll just catch this one point. So, the 14th Amendment comes after the end of slavery, and what it does, it's a very big amendment. It's very broad. And there's a lot in it. But one of the key things it does is that it establishes birthright citizenship. So if somebody's born in the United States, they're basically automatically an American citizen, which wasn't disgustingly, sadly, horribly, which wasn't the legal justification before, where people of color were considered three-fifths of a person and a shameful part of the history of the United States. And then we fast forward, the Civil War ends, slavery ends. Thankfully, the North won, but it's not over. And so now there's this question of the 14th Amendment. Well, when you apply that, part of the 14th Amendment also talks about something called privileges and immunities of citizenship. So that would mean that an indigenous Native American who had never been given proper rights therefore finally get them. And as we said, also people of color and former slaves, etc. But then there's another part to the 14th Amendment. As I told you, it's a big amendment that doesn't have anything quite to do with that. It tangentially it does, but here's what the part that I was going to tell you about with Trump's favorable Supreme Court ruling is that Colorado was one of the first states to say, we're going to apply the 14th Amendment to Donald Trump. And since I haven't told you this part yet, you might be like, what are you talking about? Well, here's what it is. The other part of the 14th Amendment, the part that we're discussing, is if you were fighting for the Confederacy, if you were fighting for the South, if you're fighting to keep slavery, then you are ineligible for elected office. So the 14th Amendment is saying all you Southern generals and all you Southern warriors trying to fight to keep slavery, you're fighting the most racist battle you could fight, and you're ripping apart the country. You can't run for office. Uh, you can't hold office anymore. So that part of the 14th Amendment, but the way it's described in the 14th Amendment later was interpreted to be just for those people in that one situation are ineligible. But the language doesn't quite say that, and so what the interpretation by Colorado was to say that if you're engaged in an insurrection, which is what the South did, the insurrection is the idea of a million words you could say. It's in this case, it's half of it's a civil war, it's a coup, it's a revolution, it's anarchy all at once. But the insurrection is what tried to happen on January 6th, and that's why all this matters, because now we fast forward to from the 14th Amendment being applied, written. I think that's a fair judgment that that's why it was written, was to specifically deal with the people that were fighting for the South. But it doesn't say that it couldn't apply elsewhere. And so January 6th was the test of that. You all know now that over 1,000 people were arrested, 10 people died, um, half of them by suicide after the events, police officers. Um, so this is a major question. And the Supreme Court has ruled that the 14th Amendment cannot be applied to January 6th, and Democrats or neutrals or libertarians or others that are nonpartisan Republicans would say that's an absolute disaster, because if that's not an insurrection, then what is? What has to happen for the insurrection part of that 14th Amendment to kick in and to preclude someone from running from office again? Meaning preclude means to disallow. So that I think that that's a fascinating thing that we should think about is, yes, the Supreme Court justices we're learning are supposed to be independent, and in many ways they very much are. You can't dock their pay, you can't increase their pay based on performance, right? They're shielded from public opinion because they don't have to run for elections. But there is a question of, do they show favoritism to the party of the president that put them there? Or if that president is still around, are they showing direct favor to that president? And so, in the case of former President Trump, Democrats and a lot of independents would say that he's getting sort of unfair special treatment, not not the Supreme Court not allowing him to be held accountable, or even go to trial. As we mentioned the other day, there's the ruling also recently 6-3 was all Republican nominated justices and all Democrat justices opposing, um, saying that presidents, when they're in acting in their official duty as presidents, have complete and total immunity. And I think you remember me telling you the dissent among the three Democrat appointed Supreme Court justices was that if this is acceptable to give everyone immunity that's been president, then they could just go assassinate other political leaders and it would be fine, because, hey, they're doing it as an official duty of the president. Republicans would probably say that's hyperbole. I think some people might say that that's a very serious concern that Justice Sonia Sotomayor has brought up. Um, a few more things, and then we'll get on to our next piece, which will be next video will be about civil and criminal courts and the differences and similarities between them. But just as a recap with the Supreme Court, they have a special ability to interpret the Constitution, and that's that judicial review. So, just if you didn't get that, the judicial review is a simple concept that the constitutional issues that come up can be ultimately resolved by the Supreme Court. Now, there are possible ways, as we've learned, to go around or over the Supreme Court. The example I just gave about the Supreme Court in Reich v. Gonzalez / Reich v. Ashcroft saying that marijuana federally is illegal, so states can't do it. That didn't have any impact, and that's because the other branches refused to enforce it, or at least starting with Obama, the presidency, the executive branch didn't enforce it. So it's interesting. The Supreme Court relies on the other branches to uphold what they say or not. Um, and the good news is that there have been times I always look for rulings that are unanimous. And I'll give you one such case before we go that you may have heard of, but if not, you definitely will probably appreciate the power of this. Um, if you ever get a chance, there's something called a movie called The Pentagon Papers. But there's a story behind it that's real life, and a guy named Daniel Ellsberg is a researcher. So he's a nerd like me that does politics and that enjoys learning. And in this case, he was tasked with going to Vietnam during the war and going there in a completely research capacity only, not in a combat way or even necessarily diplomatic way, just as a researcher. And he comes home after quite a bit of time in Vietnam, and he unleashes or starts to unleash the truth, which is that the U.S. government is not being honest with the American people about the casualties. We're not being honest about who's getting killed, what type of weapons the United States is using, our own death count for American soldiers. All kinds of different issues are brought up, and the United States government at the highest levels doesn't want this report printed. And so and this will be our final keyword of this lecture, they enacted something called prior restraint. Prior restraint is a very difficult thing to implement nowadays, and I'll tell you why. But what it is it's stopping the publication of something before it's censoring something, not once it's already been on TV or on the internet or in the newspapers. It's not, it's, to use that word again, precluding it from happening. And that's a good word to know. If I use it a lot, I apologize, but that just means to disallow it. So the government is saying you have this report, and if we could be blunt, it makes the government look bad because it shows that at the very least, what the government's telling the American people generally is inconsistent. At the most, it may be just flat out lying. And so the government tries to, and does for a short time, try to stop the New York Times from printing. Now, remember I said that this is difficult to enact and difficult to engage in because the government has to stop it before it's published for it to be prior restraint. Otherwise, it's some type of censorship or etc. But in this case, this is back in the times when, in the 1970s, there just weren't computers. It was someone Xeroxing copies all night long, sitting in a copy machine, making hundreds of pages of copies, and physically sending the pieces of paper to the New York Times. So it's not. I think it would be much harder to enforce today, and I'll give you an example of why prior restraint is harder to enforce today. There have been many people who have tried, and some succeeded, in making 3D guns from guns that work from 3D printers at home, and judges have used an injunction, said I'm issuing prior restraint, or the court is issuing prior restraint. You can't go publish this blueprint for a homemade gun that doesn't have a license for it, that you didn't buy, that is potentially, it's untrackable, and it's what's called a ghost gun. If that person gets that on the internet somehow, all someone has to do is take a screenshot of it and it's saved forever. So that's why it's much harder with prior restraint today. But it is one of those cases, and the reason I use that as an example, it's also fun to learn about and think about. But the other reason was to say that the Supreme Court had to act very quickly, and my happy ending to this story is I said I love when the Supreme Court is unanimous in their decisions. They won't always be, and realistically, they probably can't almost always be. But what I mean to say is that when 9 out of the 9 justices agree, it sends a message that there's unity, that this is clearly, forget if you're conservative or liberal, this is just what the Constitution says. And that's, to me, that's always refreshing. And in this case, the government says, excuse me, the Supreme Court says to the federal government, to the rest of it, to the executive branch, you can't hide this. This is not, you can't expect us to enforce prior restraint on what is simply just the truth. Now, could they issue prior restraint on a specific part of the report that talked about where troops were, or where it could reveal national security secrets, or that it could endanger the soldiers' lives? That is, no one would argue and win to say, oh yeah, we should be allowed to publish that. This isn't military secrets that will kill someone in these Pentagon papers that were being released. It was just inconvenient, to quote the Al Gore documentary, an inconvenient truth for the government, and they just didn't want it out there. And the Supreme Court thankfully was like, you know what? No, this is freedom of speech, and this is why we need a free press in the United States, free media, free journalists. You may not like the media per se, but no one could deny objectively that there are times when the media can be a very powerful force in keeping the government accountable. And that's really what free speech is for. So, prior restraint, very, very seldom used, but a fascinating concept to think about. Leave you there for now. Next time we talk, we'll be talking about civil and criminal courts, and we'll be going on to due process, Bill of Rights, and a bunch of other fun stuff. So, can't wait to hear from you, see your thoughts and discussions. Dialogue and debate has just been awesome, excellent, as good as you could ask for an online class. So, hey, keep up the great work. See you soon. Professor B signing off for now.